Okay, Mr. Brannick, you're up, sir.
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Humphreys & Berman. Here, along with Rob Klein, we represent the appellants, the Shears and Mr. Pasco. The issue in this case is the right of a law firm to recover a fee for work performed by a departing lawyer after that lawyer departed.
Mr. Brannick, let me just interrupt you 1 second. Are you going to reserve 5 minutes?
Yes, if I may. Thank you.
Okay, all right.
So the Shears hired Mr. Pasco while he was a partner at Austin Rowe. Before he left Austin Rowe, he put about 50 hours into the case. Mr. Pasco then left. The Shears decided that Mr. Pasco would continue to represent them and discharged Austin Rowe. After he left, he put in about another year and a half worth of work, 1,500 hours, $177,000 in costs, and achieved a spectacular result for his clients and earned a significant fee. The trial court, however, decided that that fee was owned by Austin Rowe, despite the fact that the Shears chose Mr. Pasco, despite the fact that the Shears discharged Austin Rowe, despite the fact that after Mr. Pasco left, Austin Rowe had no responsibility for the case, never met the Shears, did no work, and despite the fact that the Shears never approved any sort of fee split. We think the trial court erred and the trial court's decision has to be reversed. Florida law has long been the case that you apply quantum merit in these circumstances. Rosenberg, the Florida Supreme Court's decision in 1982, is a leading case on that. Rosenberg looks very carefully at the situation, and it says, and it rejects the concept of the former firm having some sort of property interest in the case. The case is the client's case. It's not the firm's case. And instead it says that the fee in this circumstance is divided by a quantum merit. That means that the firm gets the value of the work that was performed while Mr. Pasco was at the firm, and that Mr. Pasco gets the fee based on the work that he did after he left.
Mr. Brannick, but the cases that you're relying on, isn't the distinction here that we're dealing with an equity shareholder?
Right, but first, Rosenberg makes no such distinction. Rosenberg has a very broad holding. It basically
right, but if we look at the facts of Rosenberg, they did not involve an equity shareholder.
That's correct. But what's important is why.
And Frady's, and they did not refer to Frady's because, I mean, it was a different factual scenario. And Frady's is still, no court has abolished Frady, the rule in Frady's. I think they refer to it as the unfinished business rule, correct?
Well, actually, I would disagree with that, Your Honor.
Okay.
There are two cases following Rosenberg in situations exactly like this with a departing equity shareholder. That's the Jones case out of the first DCA, which we cite in our brief, and also the Trend Coins case decided by the third DCA in 1989. So there are cases deciding after that point. But I think going back to your original point, two important points I want to make. First is that we have to look at why Rosenberg decided the case the way it did. And it decided the case the way it did because it said that the client's choice is what controls. And that if you give the former firm a property interest in the case, you are going to be interfering with the client's choice because the client will never be able to choose the departing lawyer.
Mr. Brannick, you made that point in your brief, and I really, frankly, got to ask you some questions. Why would that be the case? Because the client basically has said, look, I am going to pay a certain fixed fee in this contingency case. Which one of you lawyers gets it and how you sort that out between yourselves is not my concern, not my business, not my worry. And I want the guy that's leaving, yeah, he's only going to get a third of the fee instead of 2/3 of the fee, but that's the way I want it to be. Why does that interfere with his choice to make that? I don't follow that argument.
Because, Your Honor, you're looking at the case at the wrong point in time. The point in time you have to look at the case is at the time that Mr. Pasco was leaving, and they go through the joint bar process and they provide the choice to the client. Look at it very practically. If you're Mr. Pasco and you are told at the time you're departing that you can put in all of the work in the case, 97% of the work in the case, you can put out 100% of the cost, $177,000, but you are not going to own this fee at the end of the case. Could you take that case? Of course you couldn't take that case. and the Shearers wouldn't be able to hire Mr. Patsko.
Well, once again, we don't know the numbers in this case, no one, because of the confidentiality, but I mean, my sort of walking around horse sense intuition says we're talking some serious buckage here. And whether you get 2/3 of that buckage or 1/3 of that buckage, it's still more money than I got in my pocket at the moment. It's a lot of money. So I still don't understand the argument.
All right, well, let me put it in simpler terms. I departed from Holland and Knight. I think Judge Black, I think you departed from McFarlane Ferguson. When you're at a large firm like that, you own a minuscule percentage of the firm. I probably owned, some small, share of 1% of the firm. If the law is the way they suggest, the client could never hire me, because the most I could ever hope to recover of this fee would be a small, minuscule percentage of 1%.
Those aren't our facts here.
Yeah,
but this is, excuse me, Your Honor, but it's not a matter of the particular facts in this case. What we're talking about is the law that applies to every single case.
Mr. Brannick, here we did the original. I mean, there's two contingency fee agreements. There's one with the former firm, right? And then one with Mr. Patsko's firm. And the former firm contingency fee agreement, was that terminated in any way? Or are you saying it was by the way that the exit was done?
Yeah, the Shearers discharged the Austin Rowe firm and hired Mr. Patsko. At that point in time, the Austin Rowe firm had no more responsibility for the case.
Okay, let's assume for my argument's sake and my question here that the default rule, the Frady's rule, applies. So the question for the court below was what percentage was supposed to be applied to Mr. Patsko's share, correct? And so I guess I would like to get into how the rationale for Mr. Patsko's argument is that it should be considered based upon what was happening while he was a shareholder versus what was happening at the time he departed. Why should we look at what was happening when he was a shareholder to determine the percentage to be applied to the contingency agreement versus at the time of his departure, where he was disassociating from the firm?
I'm not sure I fully understand the thrust of Your Honor's questions.
Well, I think your argument is that he is entitled to a greater share, correct, than what he was given.
My fallback argument, if quantum merit doesn't apply, yes, he should be entitled to a greater share.
That's what I said. Let's assume it doesn't. Okay. And the point of your argument is that that it's a factual issue. The court should have looked at the circumstances during which he was a shareholder, he was paid contingency fee cases.
There are really two things that I asked the court.
Well, that's part, yeah.
One is that when
Mr. Brannick, move closer to your mic. We're losing you. Move closer.
I'm sorry.
Yeah.
There are really two important factual points. One is what the parties actually agreed to at the time of his departure. And the facts in this case are clear that the Austin Rowe firm never claimed anything more than a quantum merit share. If you look at the letter that was sent to the Shearers.
Did they say quantum merit? Did they say quantum merit? They just said
for service. Quantum merit. But
yeah.
What they said was that you will be required to pay a fee based on the work that was done before January 31st.
Based on services. I don't know that it said work performed. Okay.
But clearly that letter, and by the way, that phrase in that letter was added specifically by Mr. Rowe. So there's a factual issue there about what did they agree to and whether the Shearers and Mr. Patsko relied on that claim of quantum merit when they made their decision to establish their representation together. And the testimony is unequivocal that both Mr. Patsko and both of the Shearers testified that they would not have entered into this arrangement if they had known that Austin Rowe was going to be seeking something more than a quantum merit share. At that point in time, and no point for the next year, did Austin Rowe ever suggest that it was entitled to anything more than quantum merit share. You will see nothing in this case, nothing in the record where Austin Rowe ever suggested that they had an ownership interest in the entire fee. So that's the first factual issue that we argue. The second factual issue we argue is, how did the partners
and let me go back so I don't miss so I don't miss something. So the argument then is a waiver argument, correct? Is that what you're
well, it's either waiver
or an
estoppel.
Okay.
I think collateral estoppel is probably the best way to put it.
Probably fits better with what you're saying. Okay.
Right. And you'll notice that there's not a single word in their answer brief about either waiver or collateral estoppel. And there's a good reason for that. It's because there's a clear factual dispute when we have testimony in the record.
Wouldn't they argue that I mean, their lien, the notices of their charging lien that they filed, they recited to the pertinent cases. I realize it was amended a few times, and the cases were added.
Look at the, if you look at the history first, you have to look at the departure letter. That departure letter very clearly is based on a quantum merit theory of recovery. Then look at the first set of liens. There's no mention of any of the cases. It's clearly a quantum merit recovery. The next one that you're referring to, Your Honor, does mention the Buckley case, but it also mentions the Searcy, Denny, and the Rosenberg cases, which are cases that support the quantum merit. So there's certainly nothing.
Mr. Brannock, there was no oral or written argument between these lawyers as to how these fees were to be split. Is that correct?
The partnership agreement doesn't address it.
Well, and they didn't have a dialogue themselves. Hey, this is how we're going to split these fees. It was sort of an assumption based on sort of communications that were not directed to that issue. Is that fair?
No, I don't think that's fair, Your Honor. I think
okay, well, help me with that.
Look at the record at page 605 to 609, and you'll see Mr. Pasco's very clear testimony in that record where he says that we had an agreement that there was going to be a quantum merit interest in those shares.
He also has other emails where he says we have no agreement, right? Aren't there other communications, emails, for example, where he says, or either a letter or an email, I don't recall, where he makes it clear in his mind there was no agreement?
I don't believe that's a fair reading of that. That's a March letter.
Isn't that what the
fair reading?
Mr. Brannock, didn't the trial judge find there was no agreement, and that's part of the reason that compelled him to look at the Freights case, because there was nothing else to go on. There was no agreement. Isn't that part of it?
Yeah, he certainly, and everybody agrees that the original partnership agreement doesn't address this at all. He decided that the parties in their settlement negotiations didn't agree on a quantum merit recovery. Our point is that if you look at Mr. Pasco's testimony, there's clearly a factual issue on that. But I'd like to, if I could, return back to the issue about Freighties, because I think it's very important to understand how limited Freighties is. Freighties is a partnership dissolution case. And that's not just a technicality, that's very important, because what happens in a partnership and dissolution is that all of the partners continue to work for the partnership until it's resolved. Everybody, all the partners put their fees into the pot, and they all share just exactly the same way that they would have before the firm had dissolved. This case is not a partnership dissolution case. Number one, it's not a partnership. It's a shareholder situation. And number two, there was a clean break. There was no wind-up period here when everyone was working for the firm. There was a break. Mr. Pasco sold back his shares, and Florida law is absolutely clear that as a shareholder, once you turn back your shares, you have no further duties to the firm. The firm has no other rights or responsibilities in connection with the work that you do. Law is absolutely clear on that. What really bothers me the most about this case is that they want to apply Freighties, but they want to apply Freighties as a one-way street. As I said before, in the partnership dissolution process, all of the partners are working together to wind up the firm, and they all share in the profits that take place during that time period. What they want here is for this court to rule that Mr. Pasco was working for the firm, but that they had no obligations to him. They're not contributing any of their profits from that period of time when he was supposedly winding up this firm. No, they want this a one-way street. That's not fair. What they want is the fruits of his labors when he was working for himself, not for Austin Rowe, but for himself and for his clients. And if we get back to Rosenberg, Rosenberg is absolutely clear. And the language of the decision could not be any broader. This is what the Rosenberg case says. We hold that an attorney employed under a valid contract who is discharged without cause before the contingency has occurred or before the client's matters have concluded can recover only the reasonable value of the services rendered prior to discharge. Clear as a bell, broad, no other cases disagreed with that.
Mr. Brannick, you're into your rebuttal time, just so you know. It's your time. You can use it any way you want.
Sure. So the only other thing that I want to mention is that Rosenberg is now confirmed by the modern rules of ethical conduct that tell us exactly how you deal with lawyer departures. The client gets to choose. The client chose Mr. Patsko here. The rules also say that the firm cannot do anything to interfere with the client's choice. The rules also say the firm can't do anything to interfere with Mr. Patsko's right to compete with the firm once he turns over his shares. And the rules also say that a firm cannot take no responsibility over a case and take a fee. The rules could not be any clearer about that. And finally, one last important point about Frady's. The partnership laws have changed since Frady's was decided. When Frady's was decided, at that point in time, each partner got to recover in accordance with their share of the firm. But now under the Uniform Partnership Act, as has been adopted by Florida, every partner is entitled to reasonable compensation for the work that they performed after they left the firm. Reasonable compensation here is certainly not giving Mr. Patsko 1/3 of the fee in a case where he did 97% of the work. I'll reserve the rest of my time for rebuttal.
You have 3.5 minutes when you come back.
Thank you, Judge.
Mr. Pope, it's your turn.
May it please the court. My name is Wally Pope. I'm here on behalf of the lien claimant off Austin Rowe Baskell, formerly known as Austin Rowe Patsko. I wanted to first just briefly touch on a couple of matters that you were concerned about in the appellant's argument. First, the letter that went to the client. The claim is that is a demand for quantum merit. It's nothing of the sort. It's really required by Rule 4-5.8 D3. Let me share that with you. In all instances, notice to the client required under this rule shall provide information concerning potential liability for fees for legal services previously rendered, cost expended, and how any deposits or fee costs will be limited. They were simply complying with the rule, that rule which was enacted by the bar in 2006, 7 years before the Buckley Towers case. Let me touch on the Rosenberg case. Rosenberg was out of the 3rd district, the very same district that decided Frady's. The 3rd district also decided Welch and Kreutzer and applied the Frady's rationale to professional associations. The Buckley Towers case, which is an 11th Circuit case that the appellants have done their best to denigrate and minimize. And I agree that it is not binding precedent when the federal court determines this question of state law based upon diversity of citizenship. It doesn't bind you at all, but it's persuasive. And the rules of the 11th Circuit even provide that it is persuasive authority. And that's how we cite it. It's really like a law review article because it traces the history of Frady's and brings it all on. For some reason, they don't cite Welch and Kreutzer. I don't understand that, but they come to the same conclusion, and that is that the Frady's rule applies to professional association. What is the underpinning of this rule? The rule arises out of the fiduciary duties of good faith and fair dealing and loyalty that apply to law firms. Law firms in many regards are like marriages. You get to know your partners exceptionally well, and there are all sorts of high duties between and among you. And that's what Frady's enforces. So let me take just a second and talk to you about Buckley Towers. The appellate's argument on pages 12 and 32 of their brief basically says that, well, Buckley was decided in 2003, which is wrong. It was decided in 2013. And arguing from that false date of 2003, they say on page 32 that Buckley Towers predates the Florida bar rule on lawyer departures. Not true. It's just, that rule was promulgated 7 years before Buckley Towers.
Well, they obviously made a mistake, and I read it that way as a mistake. But, you know, I'm less interested in that issue than I am in this issue. And if this case goes back and gets reversed, or if we were to find that summary judgment was improvidently issued because there are disputed issues of material fact about how this fee should actually be divided based on this firm's actual practice, how do we just sort of, you know, light on a shareholder percentage to divide a contingent fee when they never did that? Every year they would decide who actually brought in the most, you know, the most amount of revenue to the firm, and they would categorize percentages based on that and divide their profits that way. So why all of a sudden are we married to this percentage of shareholder interest when they never, ever, ever did that?
Because they didn't have an agreement. It was totally discretionary.
So why wouldn't we go back with what they always did?
Well, they didn't always do the same thing every year, and that's not even...
The testimony that I read said that every year they would sit down and decide who brought in what amount of revenue to the firm, assign a percentage to that, and that's how they divided the pot.
Your Honor, it was not mathematical. And let's go back to the original summary judgment here. The original partial summary judgment, everybody stipulated that there were no disputed facts. They rolled the dice that they could convince the court that Rosenberg applied. Rosenberg doesn't have a thing to do with the equity department. So they stipulated that 7 months later, without ever filing a motion for rehearing, they come up with this idea that, well, we had a course of dealing. There was no mathematical certainty to that course of dealing. The Roe affidavit, which is lengthy, and
but isn't that, Mr. Pope? Isn't that the point on summary judgment? I mean, the court has to eliminate all, you know, disputed issues of material fact. And if Mr. Patsko is saying that, well, this is not how we distributed on cases before, and why are we doing it now? And Austin Rowe is saying otherwise. I mean, don't we have to look at that and say that that's a genuine issue of material fact that shouldn't have been decided on summary judgment, and a jury should really have decided that issue?
No, Your Honor, because number one, this is an equitable proceeding, and it's
well,
not
excuse me, but at least it should have been other than a summary judgment.
No, Your Honor, because this is not a fact dispute. The question whether they have an agreement is a question of law, and that's what you said in the Acumen construction case at 616 Southern 2nd 98 that this court decided back in 93. And let me read it to you. This court has held that the existence of a valid contract is a threshold question of law for the trial court. The judge took into consideration the paper record and made a determination, and what the party said, and made a determination there was no binding contract. And for that reason, the default rule applies, and that is he gets a third of the fee. Well, that's not trivial. He gets a third of the fee. And on the fairness question,
but then can't we say then that's a reading too narrow, and that the facts in Frady's should be limited? Because if those facts don't exist in Frady's and those additional facts exist here, then maybe Frady's doesn't necessarily apply where there's these additional facts as far as the course of dealings of the parties.
I'll add to that, this clearly is not a dissolution case. I mean, and that's a huge difference.
This is a disassociation case, and the Buckley Towers case makes that distinction. But the thing about Buckley Towers is that it's like a law review article. They trace the history of all of this. This is a disassociation case, and the cases are treating a disassociation as they would a form of dissolution, because under the revised Uniform Partnership Act, when a partner withdraws, the partnership is not dissolved automatically. under the original Uniform Partnership Act, there was an automatic dissolution. So it's not dissolved under this act, and it's not dissolved. A PA is not dissolved when one party leaves. But this all goes back to really the foundational idea of being the fiduciary duties that partners owe to one another. And on the choice matter, Your Honor, you brought up the choice thing. This doesn't have to do with client choice. It has to do with lawyer choice. It has to do with Mr. Patsko making a choice, and he made one, and he doesn't like it now.
But Mr. Pope, what are the continuing fiduciary obligations of Mr. Patsko once he left?
Well, under Freites and Buckley Towers, his obligation was
well, okay. So let's talk about the facts here. What were the facts here as far as his additional obligations, his fiduciary duties?
Well, his obligation, according to Freites and Buckley Towers, is to wind up the case, and he gets his partnership share for doing it.
Can I ask you a question? And this may or may not be relevant, but suppose a different set of facts. Suppose Mr. Patsko takes this case, he works it for a year or two, he spends his $177,000, he goes to trial, he loses. Is there any obligation on the part of the prior firm to reimburse him for what he's put out?
I have certainly not seen any case ever dealing with that fact situation, and I'm not sure what the answer is, but I doubt it.
But it just seems as though if the argument is that there's an ongoing ownership interest in there, it's just a one-way interest. If it goes well, the firm gets paid. If it doesn't go well, Mr. Patsko eats it.
Well,
I don't know if that's relevant or not, but it just occurs to me as I'm listening to all this.
Well, under your scenario, the contingency never happened. So there's really nothing to fight over, and what you've got is a lawyer advancing costs. And I suppose if he wants to go back and acknowledge the Freites rule and say, look, I advance these costs, you have to pony up for him, perhaps he's got a claim. But it's not anything I thought about in preparing for this oral argument, to be frank with you.
Yeah, I understand that's not the facts here, but in studying who has an ongoing obligation and where the ownership interest in this case lies, it seems like it's on the
we are in equity, so these things, I mean, the fact that the firm that's got 3% of the interest is claiming, the whole fee is also troubling. But I mean, again, I don't know that it's relevant, but it does scream an unjust result.
Well, Your Honor, on the fairness question, I don't think that I could do any better than the trial court, which squarely addressed the fairness question on 3 different occasions. Twice in the original partial summary judgment, and once in the final summary judgment. And basically, the fairness issue cuts 2 ways. But may I just share this with you from page 4? Plaintiff's view is that Patsko, quote, Patsko will be able to draw into the deal with Austin Rowe, reaping the benefits of his efforts. Yet Freites and Buckley Towers recognize the principle that there are economic consequences between and among equity partners in a law firm. And that includes when one partner leaves and takes a firm client with him. Moreover, the departing partner is no worse off than he would have been had he stayed at the old firm. He's entitled to his partnership share of the contingency fee. What that partner is denied is the personal windfall that would come him if courts allowed a partner to simply exit whenever a high value case walked through the door, leaving the firm and the other partners in the dust. And the judge came back to that theme again, a paragraph or 2 down in his order, and he did it again on page 7 of his final summary judgment. It says the result reached here is also not unfair. It is the law as applied to the undisputed facts presented here. The parties could have contracted around the Freites-Buckley Towers rule. Patsko argues that the parties indeed did this. The court finds no evidentiary basis to reach this conclusion. The court ruled as a matter of law that there was no enforceable agreement between them. And that's the court's job. It's not a fact dispute. It's a legal question. Do the facts that were before the court, the disputed part of the facts are immaterial. The clear facts led him to conclude that there was no agreement. Now, let me just ask this question. I raised a jurisdictional question. Does the court want to hear anything about that at all?
Yeah, we need to hear that.
All right. Let me get to that point. This case took a big change when the case was settled. In January of 2019, I was contacted by the appellant's new lawyer, Mr. Klein. Mr. Klein wanted to work out an arrangement to get the money to his clients without our lien clogging up the works. Within 3 days, we worked out a deal, memorialized it with an exchange of correspondence and emails, which is in the record, and that the appellants, the sheriffs, got their money. They got everything. They paid the fee. They paid it over to Mr. Patsko, who our agreement was it went into escrow held by Mr. Klein. The appellants were out of the case. They had paid their money. We don't make a claim against them for quantum merit. Our claim is based on Frady's and Buckley Towers. We have a fallback position. Of course, if you reverse and say all you've got to do is render, you've got to do a quantum merit claim against the sheriffs, then fine, we did. But let me get to the bottom line on this thing. Why is the Frady's Buckley Towers rule beneficial to the client? They pay one fee. They don't pay two fees. I'm astonished that they are in here arguing that not only should we pay this gigantic fee to Mr. Patsko, we want to pay you more on a quantum merit. And our fee is going to be substantial if we have to do quantum merit, because when he left the firm, he already had an 8-figure settlement offer in his pocket, which he didn't tell us about until he left. So, the fairness thing cuts a couple.
Is that in our record?
It is. It is in the record.
Okay.
And in fact, it's in one of our claims of lien, our second one or the second amended one. Yes, that's in there. And it's also in Mr. Rowe's affidavit, which is at R1010, I believe. So yes, there's a lot there, but I digress. So the other point is that they added Mr. Patsko as a party to the notice of appeal. And the problem is that he consistently stated that he was not a party. In his answers to interrogatories, he swore under oath, quote, Mr. Patsko is not a party to this litigation. He objected to our written interrogatory, said, I'm not a party. The sheriffs in their initial motion for summary judgment insisted that Mr. Patsko is not a party to these proceedings. So the sheriffs are out, they paid their fee. Mr. Patsko is not a party. Who's taking the appeal? The order is directed against Mr. Klein. Mr. Klein is holding the money. The order says Mr. Klein disperse it, a third to Mr. Patsko and the rest of it to Austin Rowe. Who's appealing this thing? I mean, how can you have jurisdiction? And furthermore, how is it? One of the salutary effects of this rule is that the clients should not get sucked into a fight about lawyers grubbing over fees. They shouldn't be. And they normally wouldn't, but they have injected themselves into this case and making the argument that not only do we want to pay a full fee to Mr. Patsko, we want to pay more to the other firm. I mean, what sense does that make? How do these people even have standing to be in this court when they're complaining about an order that is completely in their favor, exonerates them completely from anything else? It just doesn't make any sense. Doesn't make any sense. And I don't know, do I have any time left or should I?
No, you have 3.5 minutes. 3 minutes and 15 seconds to be exact.
Well, let me ask the court this question, since I do like to chat. What do you want me to address right now, other than the matters that I've already addressed? I mean, I've got a notebook here with every possible issue that I could think of, and if there's anything else,
I don't have any further questions myself.
All right, then I'm not gonna bore you with any more, and I will conclude. Thank you very much.
Thank you, Mr. Pope. Mr. Brannick?
Jurisdiction is easy. The trial court decided that Mr. Patsko was the proper party to the case and took away most of his fee. He's clearly the aggrieved party here. He clearly has the right to appeal. So let's go back to the merits. This is what the letter to the shearers said. You may be liable to the firm for fees and costs for services provided by the firm and its employees, including Mr. Patsko, through the date of Wednesday, January 31st at 5 p.m. They say that that letter is just complying with the bar rules. No, that sentence in the letter was specifically added by Mr. Rowe. It's not in the bar rules. And it's specifically added, and it specifically says, we've got a claim up till January 31st. It says nothing about a claim after January 31st. That's critical here because Mr. Pope says that Mr. Patsko made a decision he doesn't like now. Well, yes, he made a decision, and the shares made a decision based on that representation and based on the similar representation that was made in all of the charging liens for the next year until December of 2017, a year later. They then changed their position. That's classic collateral estoppel. We made a decision in reliance upon their position. They changed their position, and now we've suffered great loss. There's a factual issue on that. They don't respond to it in the brief. You've got to reverse, at least on that factual question.
Mr. Brannick, you want to address the standing issue?
I tried to in my first sentence. Basically, Mr. Patsko was declared to be the party. Most of it, he was taken away. He's the aggrieved party. He has the right to appeal. We addressed this in great detail in response to motion practice, and this court has already ruled that there was jurisdiction. And I'd like, if I could, to just rely on my papers and focus a little bit more on the merits. They argue Buckley Towers. We've written a ream on Buckley Towers in the brief, so I'm not going to repeat myself. But they say that Buckley Towers is a law review article on this. Well, if it's a law review article, it deserves an F, because what it doesn't do is it never discusses the issue of client choice, which is exactly the primary point of Rosenberg, that if you give the departing firm the property interest that they seek here, the client is never going to be able to hire the existing lawyer, particularly if that existing lawyer has only a small percentage of the share. It's just practically speaking impossible. And Buckley Towers does not address that at all. In fact, not a single one of the cases that they cite that talks about Frady's ever addresses the issue of client choice. Not a one. This is the first case that really grapples with this issue. And it's important that it gets decided the right way. They spent some time talking about this so-called duty of loyalty. There is no question that while Mr. Patsko was a partner at Austin Rowe, he owed a duty of loyalty to them. Just as in Frady's, when they continued the partnership during the dissolution process, everyone owed a duty of loyalty to each other. But once Mr. Patsko sold his shares back to the firm and they paid him that $20,000, which is of course far less than he would have taken if he had known that they were going to be claiming an ownership in this case. But once he sold those shares back to the firm, the law is absolutely clear. He owes no more duty to them at all. He can compete, he can take that matter, he can work it. They have no rights to that matter at all. As I said before, they want a one-way street here. They want Mr. Patsko to be responsible to them for the work he did on that case, but they're ignoring that they're not giving him anything for the work that was done on all the other cases that were in that firm while he was there. This is not a dissolution case. Frady's doesn't apply.
You're pretty much out of time, so if you want to wrap it up, that'd be great.
The last point I want to make is this is a very interesting case. We've got this Rosenberg line of cases, and we've got two cases that have followed it in this departing lawyer situation, and we've got the Frady's line. It's very important that whatever happens here, that this court write an opinion and talk about why, if you're going to choose Frady's, you're choosing Frady's. Why, if you're choosing Rosenberg, you're choosing Rosenberg. Even the article that was the genesis of their claim, that that Florida Law Review article, says that this is a case that cries out, that needs to be written about, needs to be resolved. So we think that clearly the trial judge got it wrong for both the reason that Rosenberg, not Frady's, applies, and because there are factual issues. But whatever the court does, we would really, really stress that it's important that this issue be resolved so that so other poor lawyers don't face the same problem that these lawyers faced here. Thank you.
Gentlemen, thank you very much. This is a tough case, and we all appreciate very much lawyers of your caliber being on this case to help us get to the bottom of it. Thank you. Have a good day.